Welcome back. This is the fifth study session of ACT 219. We are going to continue our discussion on the law of contract. I will be discussing about privity of contract. This study session will teach you the principle governing the relationship between the parties in a contract, that is the offeree and the offeror, and what entitled them to sue each other but prevent a third party from doing so, as well as the exemption to this principle. You will also learn how a contract can be discharged. On completion of this study session, you should be able to explain doctrine of privity of contract. You should be able to list and explain how a contract can be discharged, and you should be able to explain the remedies for breach of contract. Now, what do we mean when we say privity of contract? The doctrine of privity of contract is the in common law provides that a contract cannot confer rights or impose obligations arising under it on any person or agent except the party to it. For example, if Mr. A makes a contract with Mr. B, he comes under a legal obligation to pay damages if he fails to keep his promise. The enforceability or liability as regard to this contract lie firmly in the hands of A and B, excluding others. This is the foundation of the doctrine of privity of contract. The assumption of doctrine of privity of contract is that only parties to contract should be able to enforce their rights or claim damages. Now, the exemption to doctrine of privity. The doctrine of privity of contract is said to be harsh and unjust in its application, as it can defeat the intention of the promisee, because the person for whose benefit the contract was made cannot enforce it. The law has recognized that with the increasingly complex world of commerce, there must be some changes to accommodate certain exemptions to the general rule and guarantee restitution to the aggrieved. This is what led to the exception to the doctrine of privity. Now, the exemptions are: 1. Assignment of contractual rights. An assignment takes place where one party transfers his contractual rights to another party who is a stranger to the contract, thereby giving that stranger the right to enforce the contract in his own name, where the legal requirements are satisfied, as in the case of RT Briscoe versus Universal Insurance. Another exemption is covenants running with the land. Another exception to doctrine of privity is in relation to covenant running with the land. Section 5 of Real Property Act 1845 equally gives a stranger to a contract involving land the right to sue, even if he is not in a party of the contract. You know, that is what make the third person, the person, you know, when you buy a land from one of the family member and another family member that is not involved in the transaction takes the matter to the court for the solution. That is another type of exception. Now, there is another type, that's the third exemption, that's insurance contracts. According to Section 6, subsection 3 of Motor Vehicle Insurance Act, it gives a third party of a contract of insurance in respect of any liability which the policy purports to cover in respect of those person or class of person, as illustrated by the case of Sule versus Norwich Fire Insurance Society Limited. Another exception is the trust concept. The trust concept has been used to bypass the harsh effect of privity of contract, where a person has rights which he is bound to exercise on behalf of another or for accomplishment of some particular purpose, is said to have those rights in trust for another or for that person, and he is called a trustee. Now, another exemption is agency. In agency, the agent enter into contractual relationship with third party for the benefit of his principal. This is what operates when you rent an apartment through an agent. You know, the agent is going to be a intermediary between you and the landlord, so the landlord can enforce the law. Now, generally speaking, the discharge of contract is when the contractual relationship between the two parties that enter into a contract has come to an end, and the parties are free from their obligation to each other. A contract can be discharged in one of the following ways. One, by agreement. This is when both parties agree to bring the contract to an end and release each other from the contractual obligation. For a contract to be discharged through agreement, there must be an accord, that is, each party must agree to end the contract, and the agreement must be freely given and the agreement must be satisfactory, that is, each party must be satisfied with the agreement. Another one is by performance. This is when both parties have fully participated in their contractual agreement, that is, they have performed what they agreed upon. Now, another way by which an agreement and a contract can be discharged is by breach. Where there is a breach in contractual agreement, the innocent party have the right to bring the contract to an end, and it can also claim some damages. And the fourth one, that's the last means by which a contract can be discharged, is by frustration. A contract may be frustrated where there exists a change in circumstances after the contract was made, which is not the fault of either party, and it rendered the contract either impossible to perform or deprive the contract of its commercial purpose. Where a contract is found to be frustrated, each party is discharged from future obligation under the contract, and neither party may sue for breach. Now, remedies for breach of contract. In a situation where there is breach in contract between parties, that is, when someone doesn't do what they said they would do in a contract, common law provides for some remedies. In such case, these remedies include damages, specific performance, or injunction. What do we mean when we say damages? Damages is also known as a compensatory damages. It covers the loss the non-breaching party received as a result of the breach in contract. The amount awarded is intended to make good or replace the loss caused by the breach. Now, on specific performance, this is an equitable relief by which the court directs the defendant to perform the contract which he has made in accordance with his team. The remedy of specific performance was invented to meet cases where the ordinary common law remedy of damage would not be adequate to compensate for the breach in contract. And the last one is injunction. Injunction is an order by which a party is required to do or refrain from doing a particular thing. So where a party to a contract decided not to do something, a court by way of injunction can restrain him from doing that which he has undertaken not to do by virtue of his contract. We have come to the end of this study, but before we go, let's do a quick summary. We have discussed about privity of contract, we have explained how a contract can be discharged, and we have discussed about various remedies for breach of contract. You can read more from your study pack to understand the subject discussed in this video better. Thank you for listening. See you in the next class.